The time has come for reasoning patriots to question the status quo. The United States Declaration of Independence and Constitution clearly states that all powers of government are held and derived by we the people, not we the judges of the Supreme Court. And since the early 1970s, there has been a disturbing trend in the United States of the judiciary branch, also known as the Supreme Court, being the ultimate power center for governance. And this is in contradiction of what the Founding Fathers intended, which was for the judicial branch to be the weakest, not equal to, the legislative and executive branches in authority. Fast forward to 2020, and this is now completely reversed in many regards. Having all final power and authority in one centralized branch of government is despotic and ultimately tyrannical. So, is the United States Supreme Court that has evolved into what it is today a despotic branch of government? Consequently, would this make our current governmental system tyrannical by nature? Let's look at the dictionary definition of despotism to get a more defined interpretation of the word. Despotism. 1. The exercise of absolute power, especially in a cruel and oppressive way. 2. A country or political system where the ruler holds absolute power. Our Founding Fathers warned us of a despotic judiciary and its erosion of the people's power to rule. Abraham Lincoln in 1861 agreed with their warnings regarding the judicial branch by saying, "If the policy of the government upon vital questions is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers." And Abraham Lincoln also said, the people are the rightful masters of both Congress and courts, not to overthrow the Constitution, but to overthrow the men who pervert it." Furthermore, if the Supreme Court of the United States is to be the final arbiter of law, doesn't that encroach on states' rights and the will of their citizens? The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people. 10th Amendment of the United States Bill of Rights. It is time we started listening to the great patriot leaders of our past again, and not rely so heavily on the views of the subpar, incompetent ones we have today. President Thomas Jefferson was probably one of the most vocal critics of the Supreme Court, besides Abraham Lincoln in later years. His scathing views of the judiciary branch should be read by every American conservative constitutionalist today. You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and the privileges of their court. And their power, the more dangerous as they are in office for life, and not responsible, as the other functionaries are, to the elective control. The Constitution has erected no such single tribunal, knowing that, to whatever hands confided, with the corruptions of time and party, its members would become despots. It has more wisely made all the departments co-equal and co-sovereign within themselves. When the legislative or executive functionaries act unconstitutionally, they are responsible to the people in their elective capacity. The exemption of the judges from that is quite dangerous enough. I know no safe depository of the ultimate powers of the society, but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuse of constitutional power. Thomas Jefferson, letter to William Charles Jarvis, September 28th, 1820. On September 11th, 1804, Thomas Jefferson wrote a letter to Abigail Adams saying, "Nothing in the Constitution has given them, the Supreme Court judges, a right to decide for the executive, more than to the executive to decide for them. But the opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also, in their spheres, would make the judiciary a despotic branch." On September 6, 1819, Thomas Jefferson, in a letter to Judge Spencer Roane, said, "The Constitution on this hypothesis is a mere thing was in the hands of the judiciary, which they may twist and shape into any form they please." Then, on October 31st, 1823, Thomas Jefferson wrote the following to Monsieur A. Corre. "At the establishment of our constitutions, the judiciary bodies were supposed to be the most helpless and harmless members of the government. Experience, however, soon showed in what way they were to become the most dangerous. That the insufficiency of the means provided for their removal gave them a freehold and irresponsibility in office. That their decisions, seeming to concern individual suitors only, passed silent and unheeded by the public at large. That these decisions, nevertheless, become law by precedent, sapping by little and little the foundations of the Constitution and working its change by construction, before anyone has perceived that invisible and helpless worm has been busily employed in consuming its substance. In truth, man is not made to be trusted for life, if secured against all liability to account." Thomas Jefferson was not the only founding father critical of the judicial branch federal government authority. James Madison vocalized his views frequently regarding limiting the power of the feds. When you read the below quotes from Madison, keep in mind what many political leaders in Washington, D.C. are attempting to do today. "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects as war, peace, negotiation, and foreign commerce. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives and liberties and properties of the people, and the internal order, improvement, and posterity of the state." Federalist Paper number 45, January 26, 1788. Quote number 2. "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." James Madison, The Federalist Papers, number 47, January 30th, 1788. Hamilton declares that state rights usurp federal in the Federalist Papers, number 32. The plan of the Constitutional Convention aims only at a partial union or consolidation. The state governments would clearly retain all the rights of sovereignty which they before had and which were not, by that act, exclusively delegated to the United States. Alexander Hamilton in the Federalist Papers number 78, 1788, wrote eloquently the following regarding the judicial branch. Whoever attentively considers the different departments of the power must perceive that, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislator not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may be truly said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. And Hamilton strikes again in the Federalist Papers number 81. There is not a syllable in the plan, Constitution, under consideration which directly empowers the national courts to construe the laws according to the spirit of the Constitution, or which gives them any greater latitude in this respect than may be claimed by the courts of every state. Another noteworthy person to mention regarding the detriments of a too powerful judiciary is Baron Montesquieu, a French judge and philosopher. Even though he is not a founding father, his writings had great impact on them. The below was from his book titled Spirits of the Laws, first published in 1748. Nor is there liberty if the power of judging is not separated from legislative power and from executive power. If it were joined to legislative power, the power over life and liberty of the citizens would be arbitrary, for the judge would be the legislator. A major societal shift by the elite class regarding the power of the judiciary and the interpretation of the Constitution happened during the Progressive era in the 1920s. From that period onwards, the Constitution of the United States is considered a living constitution, so its meaning is ever-changing and dynamic, and this characterization of the Constitution has gained much ground amongst the ruling classes, especially in the world of academia. Such thinking is a blatant erosion of the 10th Amendment, states' rights, the core principles of the Constitution, and the intent of the Founding Fathers. And who are the ones that will interpret the dynamic living Constitution? The judges, of course, the same judges that attended liberal law schools with liberal progressive professors. You get the picture. Any reasoning person with intellect can quickly discern this is a power grab. When their Supreme Court justices' rulings become the law of the land with virtually no recourse to challenge the ruling, then that is by its very definition despotism, and what the Founding Fathers feared the most. This member, judiciary branch, of the government was at first considered as the most harmless and helpless of all its organs, but it has proved that the power of declaring what the law is ad libitum, by sapping and mining slightly and without alarm the foundations of the Constitution, can do what open force would not dare to attempt. Thomas Jefferson, letter to Edward Livingston, 1825. May God bless the United States.